Welcome to Employment Law This Week. I'm George Whipple. Employers are recalibrating return-to-work plans and policies in response to rising case numbers, CDC guidance, the FDA's full approval of the Pfizer BioNTech vaccine for those 16 and over, and updated guidance from OSHA. Epstein, Becker, Green's Robert O'Hara and Neresa De Biasi tell us what OSHA's recent changes mean for employers.
On August 13th, OSHA provided new guidance to employers, specifically a couple of key items. One, and the most interesting and important for all employers, is their recommendation following CDC's guidance from July 27th that individuals, even if they're vaccinated, wear masks inside the workplace. They continue to focus on vaccination as an issue. They want employers to promote vaccination in any way that they can. And this is just another attempt to tell people vaccination is important. With respect to the healthcare setting, the emergency temporary standard that they implemented a few months ago for the healthcare space, which is mandatory for healthcare, they are now going to be updating that, reviewing it and updating it on a 30-day cycle. I thought it was interesting that OSHA, and again in another footnote, talks about record keeping. And for those individual employers who have record keeping obligations, in the OSHA world, not everyone does, but many companies and many organizations do. Ordinarily, if you get sick in the workplace and it's tied to the workplace, like you're exposed to someone with COVID in the workplace, and that's the only way you could have got it, it's work related, you're required to keep track of that. You're required to keep a record of that. But what OSHA is doing here with respect to the vaccines is they're not going to require employers to keep a record of any adverse reactions to a vaccination. It's fascinating. They're focusing so strongly on getting people vaccinated that they specifically state they don't want to provide any ammunition for people not to get vaccinated or for employers not to have their employees vaccinated. So they're relieving employers of the record-keeping obligation for an adverse vaccine reaction until May of 2022. For employers, what the new guidance basically does is add another feature. They're adding recommendations, again, not mandatory, but recommendations that are being provided by CDC with respect to mask wearing and testing with respect to anybody that's identified with COVID in the workplace from a coworker or what have you. It's really more another layer of protection. They're not requiring it. In the non-healthcare space, there's a separate whole scheme for the emergency temporary standard that healthcare has to deal with. Much more burdensome, many, many more requirements that are regulatory and, penalties for non-compliance. But this guidance really focuses on the non-healthcare rest of the economy. So it's important for them to really refocus everyone's attention on specifically vaccination. They're really pushing vaccination for employers to push it as best they can for their employees to try to help stamp out COVID and the variant.
We are seeing a split on how unions are reacting to COVID-19 vaccination policies in workplaces. Some unions are criticizing employers for not implementing stricter vaccination policies, while others are vowing to fight any vaccination policy imposed on the employees they represent. Since the mandatory vaccination policy would affect the terms and conditions of employment for union-represented employees, under the National Labor Relations Act, an employer generally will have a duty to bargain with the union about implementing such a policy. Of course, it is important for each employer to review its contracts to determine whether a CBA already addresses the issue, either specifically or under a broad management's rights clause. For example, many contracts between hospitals and employers already recognize a right to require vaccinations. Bargaining aside, employee protest on mandatory vaccination programs may be considered protected concerted activity under federal labor law, and employers should exercise caution when considering disciplining employees for such conduct.
Thanks, Neresa and Bob, and thank you very much for watching. We'll see you next time.